If you believe the American system exists to restrain power before it breaks the rules, then what just happened should stop you cold. This was not a political signal. It was not a legal disagreement. It was the constitutional system stepping forward and drawing a hard line for the first time in United States history. The Supreme Court did not hesitate. It closed ranks unanimously and stripped a former president of every remaining legal shield at 4:47 p.m. yesterday. Donald Trump's legal operation went silent. Not coordinated silence, not strategic silence. The kind of silence that follows impact. Phones stopped lighting up. No statements, no leaks, no counter-narrative. According to people familiar with the moment, this was the sound of a defense. Architecture collapsing in real time, 18 hours earlier, while most of the country slept. The Supreme Court of the United States issued a ruling that was not incremental, not cautious, and not reversible. In a single sweep, it dismantled every legal protection Trump had constructed over 3 years. Presidential immunity, executive privilege. Procedural delays stretched across 4 criminal prosecutions and dozens of civil cases, gone, let that. Land in 247 years of constitutional history, the court has never done this to a former president. Not Nixon, not Clinton, not anyone. This was not a trimming of authority. It was a full removal of cover. And here is the detail that froze Washington. The 3 justices Trump personally appointed, the ones expected to serve as his firewall, voted against him, all of them. The ruling was 9-0. No concurrences, no dissents. No hedging language for future reinterpretation. Publicly, the court released 63 pages of dense legal reasoning designed to withstand decades of scrutiny. But that was only the surface layer. There is also a sealed appendix. 47 classified pages restricted to the justices and attorneys of record. According to sources with direct knowledge of its contents, one paragraph in that appendix carries consequences far beyond doctrine. Immediate criminal referral. Multiple jurisdictions. 3 separate grand juries potentially activated by a single block of evidence. This is where the story stops being about law and starts being about institutional response. Because this outcome is not where the court began. Early drafts tell a very different story. Justice Clarence Thomas prepared a lengthy dissent defending absolute presidential immunity. Justice Samuel Alito was aligned with him. Justice Brett Kavanaugh was leaning in that direction. That alignment made sense. It matched decades of judicial caution. Then January 8th happened. On that day, the justices received a classified briefing from the Department of Justice. 2 hours, closed doors. No transcripts. The subject was not politics, it was national security. Implications tied directly to the Trump cases. What was said remains classified, but the reaction is visible. Thomas withdrew his dissent. Alito never filed his concurrence. Kavanaugh reversed course. The opinion locked into unanimity. Whatever they were shown overrode ideology, loyalty, and long-held concern about presidential power. Protecting Trump was judged more dangerous than exposing him. That is an extraordinary threshold, and the system did not stop there. Buried deep inside the ruling is a procedural trigger most headlines missed. Donald Trump has 14 days to formally respond. That clock is now running. Constitutional law experts describe this requirement as a trap, not rhetorical, structural. Any substantive response risks self-incrimination across multiple cases. Silence, on the other hand, carries legal consequences of its own. There is no safe option. The court did not simply resolve a dispute. It asserted jurisdiction over presidential conduct in a way that permanently alters the operating environment for every future executive. This ruling was written not only to decide Trump's fate, but to remove an entire category of defense from the presidential toolkit. And the justices knew exactly who they were ruling against. They knew the political fallout. They knew the pressure. And they moved anyway. Which raises the question Washington is now circling, but not yet asking out loud. What did the court see that convinced it the risk of inaction was greater than the risk of confrontation? The answer begins with how the system walked itself into this corner, slowly, methodically. The first and most consequential mistake was overplaying presidential immunity. In February 2024, the D.C. Circuit Court rejected Trump's claim of absolute immunity. The ruling was narrow, precise, and explicit. The theory did not hold. At that moment, Trump's legal team still had options. They could pivot to factual defenses, narrow exposure, protect time. They chose none of that. Instead, they filed an emergency application to the Supreme Court. The expectation was familiar. Delay hearings. Maybe even a favorable ruling from a conservative majority. What they got was silence. For 11 months, the court said nothing. No schedule, no arguments, no leaks. Trump's lawyers interpreted that silence as internal. Disagreement, they were wrong. That silence was alignment. The court was not debating whether Trump deserved protection. It was constructing an opinion designed to close the immunity door permanently, not just for Trump, but for every future president tempted to use it. This was not case management. It was institutional housekeeping. The second mistake was assuming prosecutors had already revealed their strongest witnesses. They had not. While attention focused on Mark Meadows, the decisive witness remained hidden in plain sight, referred to only as executive one assistant. This individual was present for phone calls Trump claims never happened. Present in meetings Trump described as routine. According to court records, this witness kept contemporaneous handwritten notes dated, time-stamped, and exhaustive. 917 pages, minute by minute, documentation of the panic inside the White House as January 6th spiraled out of control. That kind of evidence does not argue. It accumulates, and at that point, the fight stopped being about interpretation and started becoming about exposure. The third mistake was geographical, and possibly the most damaging of all. Trump's team treated Georgia as a sideshow, while attention stayed on federal prosecutions. The Fulton County District Attorney was building something structurally different, a state-level racketeering case. Same conduct, same witnesses. Same timeline. Here is the trap they missed. The Supreme Court's ruling did not limit itself to federal court. It explicitly stated that the immunity analysis applies equally to state proceedings. One sentence, every plan Georgia defense erased instantly. The trial date prosecutors have pushed for is April 15th, and unlike federal convictions, state convictions cannot be wiped away by a presidential pardon. There is no override, no emergency lever. Once that clicked into focus, pressure multiplied. Then came the fourth mistake, neglecting the civil side while Trump's legal operation prioritized criminal exposure. Massive civil judgments waited quietly in the background. $83 million for defamation, $454 million for financial fraud in New York. Those judgments were stayed largely on arguments tied to immunity and executive privilege. The Supreme Court erased those arguments in a single stroke. Asset seizure can now begin within 30 days. Commercial properties, accounts, leverage shifts from litigation to enforcement at this point. The system was no longer applying pressure from one direction. It was compressing from all sides. Trump's lawyers searched for exits. The first was procedural. An emergency stay request filed directly with Justice Alito. He rejected it in 4 hours. That detail matters. Emergency stays usually take days. A 4-hour denial signals the justice had already seen the full record, including the sealed appendix, and found the claims unworthy of delay. The second attempt was doctrinal, the political question doctrine. The court anticipated it and dismantled it in advance, explaining why criminal prosecution of a former president is not a political question. That door was sealed. The third attempt was the most extreme, challenging the Supreme Court's own jurisdiction. 3 lawyers refused to sign their names to it and walked away. What replaced those exits was something more dangerous. The mechanics of the ruling itself. The court stated plainly that no person in the United States, sitting or former president, included stands beyond criminal law when private acts are alleged. Then came the evidentiary shift. Prosecutors no longer need to prove Trump knew his actions were illegal, only that he ignored clear warnings. There are 17 written warnings from White House counsel Pat Cipollone, stating Trump's plans violated federal law. 17 executive privilege was also narrowed. Communications made in furtherance of criminal activity are no longer protected, including presidential communications. Finally, document production. If Trump claims privilege, he must submit documents for in-camera review. If criminal conduct appears, the privilege evaporates. This is not negotiation. It is a funnel. Once you see how these mechanisms interlock, the broader picture becomes unavoidable. This is no longer a single defendant facing isolated cases. This is a system synchronizing its levers: criminal, civil, federal, state, each reinforcing the other. At this stage, timing becomes the weapon. February 7th is the first collision point. Document production. Trump must comply or refuse. Compliance risks turning documents into evidence across multiple cases. Refusal risks contempt and obstruction. No neutral option. February 15th, the Georgia hearing, not procedural. Strategic recalibration. Immunity is gone. Speed becomes viable. March 4th, the federal election interference case resumes. The question is no longer if it proceeds, but how fast. March 15th, civil enforcement returns. New York fraud judgment becomes enforceable. Asset seizure moves from theory to action. April 1st, the classified documents case in Florida. Delays evaporate. April 15th, Georgia again. RICO trial. State law. No pardon, no escape. This is not a linear path. It is convergence. Evidence migrates between cases. Testimony in Georgia strengthens Washington. Civil enforcement reshapes bargaining power elsewhere. There is no firewall between proceedings. At this phase, the system stops asking whether a defendant is ready. It executes its own timetable. Which brings us to the broader question this moment forces into the open. There are 3 futures implied by this alignment. In the first, accountability holds. Trials proceed. Evidence is tested. Juries deliberate. Verdicts follow the rules. The cost is volatility. The result is institutional credibility. In the second, accountability collapses. Pressure overwhelms process. Cases unravel. No verdict arrives. The precedent is absorbed quietly. Power can outlast law. In the third, the system fractures. Federal and state rulings diverge. Legitimacy becomes conditional. Law becomes contested terrain. History offers examples of all 3. They do not announce themselves. They reveal themselves through accumulation. This is why the next signals matter. Watch for former White House counsel speaking publicly. Lawyers like Pat Cipollone do not talk casually. When they do, privilege has usually fallen. Watch the timing of Mike Pence's testimony. Early movement means acceleration, not probing. Watch the silence. When former defenders stop speaking entirely, absence becomes the message. This is not about predicting an outcome. It is about recognizing a phase. Change. The institutions have aligned their tools. The calendar is advancing. The pressure is compounding at this point. The most consequential decision may no longer belong to prosecutors or judges. It may belong to the defendant himself. Does Donald Trump choose to operate inside a system that has stripped away his protections? Or does he decide confrontation is preferable to submission? And if a former president openly tests that boundary, the question that follows is not just what happens to him, but what happens to a constitutional order that has now reached the moment where it must enforce its limits or admit that it cannot. Because systems do not get many moments like this. They either hold or they reveal where the line truly was all along. Thank you for listening. If this breakdown helped you understand what's unfolding beneath the headlines, share your perspective in the comments. Hit like, subscribe, and turn on notifications so you don't miss what happens next. Because this story is no longer slowing down, it's accelerating.